Good evening. At this time, I'd like to call to order the Planning Commission meeting of October 10th, 2022. For viewers watching at home, some members of the public may be participating via video conference or teleconference. Please stand and join me in reciting the Pledge of Allegiance. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Will the secretary please call the roll?
Commissioner Buss?
Present.
Commissioner Lanson?
Here.
Commissioner Link?
I'm here.
Commissioner McMahon? Here. Chair Newman?
Here. We move now to written comments, announcements, supplemental packet, and continuances. Mr. Dugan, are there any documents like that?
Not really. We don't have any supplemental packets or additional written correspondence for tonight. I do want to take the opportunity, though, to introduce our newest addition to our planning team, Scott Kolwitz, who will be making the presentation tonight. Scott has a master in town planning, and he's been planning manager both in the city of Oxnard and city of Ventura. Comes highly recommended, and we're happy to have him on our team.
Mr. Kolwitz, welcome. We're looking forward to hearing from you.
Thank you.
I understand from the secretary that we do not have public comment tonight.
No.
Thank you. So we will move next to our consent calendar with the minutes of our September 26th Planning Commission meeting and also the 2023 Planning Commission schedule. Are there comments, or do commissioners wish to make a motion at this time? Commissioner Lanson.
Thank you, Chair Newman. I would move that we approve the minutes and the planning meeting schedule.
Thank you. Commissioners, is there any discussion, editorial comments, wisecracks about the minutes? Not hearing any, I'll ask the secretary to prepare us for a vote.
Commissioner Buss?
Aye.
Commissioner Lanson?
Aye.
Commissioner Link?
Aye.
Commissioner McMahon? Aye. Chair Newman?
Aye.
Motion carries 5-0.
Thank you. And we move now to our one public hearing for this evening. Will the secretary please open the public hearing?
Hearing having been advertised as required by law is hereby open to consider Agenda Item 7A, Municipal Code Amendment MCA 2022-70571, and Specific Plan Amendment SPA 2022-70799 to adopt a resolution recommending that the City Council introduce an ordinance to amend the Thousand Oaks Boulevard Specific Plan and the Municipal Code to modify existing standards and establish new development and zoning standards related to self-storage, mini-storage, and similar uses in certain zones, and to determine the ordinance to be exempt from CEQA. Specifically, amendments are proposed to SP-20 Appendix A, the Land Use Table, and the following sections in the Municipal Code, Title 9, Chapter 4. Add Section 9-4.2528, Self-Storage Facilities, in Article 25. Amend Section 9-4.202, Definitions, in Article 2. Amend Section 9-4-2105, Permitted Use Matrix, Non-Residential Zones, in Section 9-4-2106, Limitations on Specific Uses, in Article 21, and amend Sections 9-4.2402, Parking Spaces Required, in Article 24. Located citywide, the applicant is City of Thousand Oaks.
Bravo. Mr. Kolwitz, the floor is yours.
Thank you, Chair Newman, members of the Planning Commission, members of the public. Tonight, in an abbreviated form, we're here to talk about self-storage facility regulations, specifically municipal code amendment and an amendment to Thousand Oaks Boulevard Specific Plan, also known as SP-20. So the request before you this evening, as our recording secretary just read into the record, is to find that the municipal code and specific plan amendments are exempt from the provisions of the California Environmental Quality Act, also known as CEQA, pursuant to CEQA guidelines sections 15060C2 and 3, as well as 15061B3. and adopt a resolution recommending that the City Council introduce an ordinance amending the Thousand Oaks Boulevard specific plan and the Thousand Oaks Municipal Code to modify existing standards and establish new development and zoning standards related to self-storage and similar uses in certain zones, and to recommend to the City Council to determine that the amendments are indeed exempt from CEQA. The Thousand Oaks Municipal Code does require that the Planning Commission hold the public hearing and make a recommendation back to the City Council on the adoption, denial, or alteration of the proposed amendments. The City Council will then review and hold a public hearing of their own prior to taking final action. That meeting is currently scheduled to take place in about 2 weeks on October 25th. Some background for the Planning Commission and members of the public. On January 25th and February 22nd of this year, the City Council adopted 2 interim urgency ordinances to impose a total 1-year moratorium on city approval or issuance of any permit, license, or entitlement relating to applications for the development of construction of self-storage facilities, and the City Council initiated code revisions declaring the intent to consider new and/or revised development standards, processes, and findings for new or modified self-storage facilities to be incorporated into the city's regulatory documents. Staff was tasked with a few items. First, we were asked to conduct a comparative analysis of other jurisdictions' regulations. Second, we were to propose updated standards. And third, evaluate the potential citywide economic impacts of allowing a proliferation of self-storage facilities in consideration of the short and long-term impacts of utilizing land areas for operations that do not create substantial employment opportunities. The proposed regulations are to be presented to the City Council at a public hearing prior to the expiration of the moratorium, which would occur on January 25th, 2023. So I want to take you through our methodology of how we got to where we are today. So staff has methodically evaluated existing city codes, gathered data about existing self-storage facilities, reviewed and evaluated self-storage regulations of other jurisdictions, and we reviewed self-storage industry publications. Comparison cities were chosen as they were either in or immediately adjacent to Ventura County because they had a similar size and socioeconomics, or because they were mentioned in industry publications. Staff reviewed scores of widely available self-storage literature published online. And in September, staff met with both existing operators and invited developers to a meeting to share the proposed code revisions. This collective research has been used to assist the city in crafting the proposed definitions and regulations for consideration by the Planning Commission and City Council. As proposed, the regulations would only pertain to future self-storage future self-storage facilities, and proposed additions or modifications to existing facilities. If the proposed regulations are adopted, existing self-storage facility operators could continue to lawfully operate their facility consistent with their existing permit, which is in effect as of the date the municipal code amendment and the specific plan was adopted. So walking everyone through the adjacent jurisdictions, what we found was that the City of Thousand Oaks and Camarillo have the largest number of traditional self-storage facilities of any city in Ventura County. As of the date of the first moratorium, the city was processing 2 pre-applications requests. After the adoption of the moratoriums, both of those applications were withdrawn and are no longer being processed. The city continues to receive numerous inquiries to develop self-storage facilities, which can accommodate both traditional self-storage facilities or new transportable pod facilities. The existing regulations currently allow self-storage facilities to be located in 3 zones: the C2 zone, the M1 zone, and the M2 zones. And additionally, the Thousand Oaks Boulevard specific plan allows for self-storage facilities which do not front directly onto Thousand Oaks Boulevard. A summary of the existing facilities. What we found was the city has 15 traditional self-storage facilities approved in the community, including one that's currently under construction. And there are 2 specialty storage facilities in addition to those 15 for vehicles and other large-scale items. The self-storage buildings range in size from 18,000 square feet to just over 200,000 square feet, and they're predominantly located on the 101 freeway corridor as shown on this image. Since 2020, a new self-storage facility has been approved and is under construction at 2650 Willow Lane. Additionally, there was the conversion of an existing industrial facility that was approved and constructed at 2451 Townsgate Road. You all might remember that one as the Jafra Cosmetic Buildings that could be seen from Highway 101. Continuing with existing facilities, over the decades, self-storage facilities have been developed throughout the city. While self-storage facilities are located within 3 specific zones in the city, they are predominantly found in the M1 zone. Self-storage facilities are also found in parcels which vary in size, but a third of those parcels are 2 acres or less. Self-storage facilities also occupy buildings which have a fairly even distribution of sizes. Thinking about self-storage facilities in the context of economic development, we wanted to point out that the city's current vacancy rates for commercial uses is 6.3% and industrial uses is 4.2%. A 5% vacancy rate typically signifies a healthy market. Vacancy rates under 5% typically result in higher costs to the end users. As this relates to self-storage facilities, the development of additional self-storage facilities in the C2, M1, M2 zones and within the Thousand Oaks Boulevard specific plan could reduce land and buildings available to other retail and industrial uses, including biotech and life science. And that could further decrease vacancy rates associated with those uses and lands. In terms of the self-storage regulations on the books today, in addition to development standards associated with C2, M1, and M2 zones and the Thousand Oaks Boulevard specific properties, the city's current self-storage facility regulations are limited to the following 4 limitations which are seen on the screen. In short, there's not a lot of extra regulations that we have relative to these particular facilities. Procedurally, a planning commission level special use permit is necessary for facilities in the C2 zone and for sites within 400 feet of residential zones in the M1 and M2 zones. An administrative level development permit is required in the M1 and M2 zones for locations that are beyond 400 feet from residential zones and are not seeking certain development standard waivers. An administrative level SUP is also required for SP 20 properties that do not front onto Thousand Oaks Boulevard. Entitlement findings to approve either a development plan or a special use permit include the following. The project is consistent with the Thousand Oaks General Plan. The project complies with the applicable laws, regulations, and policies, including the Thousand Oaks Municipal Code. The project will not be detrimental to the public health, safety, or general welfare, and the project has been reviewed in conformance with CEQA. Special use permits, when they are required, evaluate operational characteristics that may or may not be appropriate for certain areas. And as such, a unique 5th finding must be made to approve a special use permit. Specifically, that finding is the proposed use at the proposed location will be compatible with the land uses in their vicinity. So as we looked at jurisdictional trends, we wanted to let you know that we looked at 24 different jurisdictions in Southern California to get a wide swath of what's happening with different municipalities. And through a comparative analysis, staff has identified that, first, communities regularly require a discretionary permit for self-storage facilities, and there are a wide range of ways to regulate self-storage uses to alleviate potential community impacts associated with self-storage facilities. In short, there's no one way to regulate self-storage facilities. And as such, the City of Thousand Oaks staff picked and chose different standards that we thought were most applicable to our community. Evaluation of municipal code standards identified common self-storage facility themes. First and foremost, they are located primarily in industrial areas. Caretaker units are required. Separate planning entitlements are required for the structure and the use. Self-storage specific parking regulations are normal, and prohibitions on habitation within the units, the sale of distribution goods from the units, and the prohibition of storage of hazardous materials from within the units are all typical. We also wanted to provide some information regarding the industry. So, again, we reviewed scores of widely available self-storage literature published online. And a review of that literature provided a history of the self-storage industry evolving from unconditioned buildings with easy exterior access in the 1960s to multi-storied conditioned buildings with higher architectural and landscape standards today. The Self-Storage Association's literature indicated that the most common state-of-the-art facility will be a 60 to 80,000 square foot building. And parcel sizes varied depending on urban to rural locations, but staff was unable to find a specific range of the size of parcels. Additionally, individuals and businesses store materials for a variety of reasons. As seen on these graphs, the business community nationwide accounts for about 16% of the self-storage facility buildings. And what was interesting is that niche storage interests were repeatedly mentioned as an area of growth. And an example of a niche storage interest would include either the storage of personal wine collections or storage for pharmaceutical companies. Staff's evaluation of self-storage literature and discussions with the self-storage operators identified the following industry trends. First, fully automated facilities are on the rise. Robust security systems are often provided. Climate-controlled buildings and units are provided, especially for those niche industries. Higher architectural standards are being required. They're turning away from the exterior roll-up door facilities. And there's an introduction of mixed-use facilities consisting of office, retail, and/or restaurant uses along the frontages of these buildings. And finally, the interior recreation vehicle storage for collector vehicles and boat storage is on the rise as well. So taking all those items into consideration, staff's survey of multiple jurisdictions and the industry trends resulted in an acknowledgement that the city standards could benefit from an update. The goals and policies of the city's general plan include the development of additional tools that will enable industrial, commercial, and residential development to flourish in an efficient and compatible manner. To move towards accomplishing this goal, it has been determined that there is a need to provide further regulations for self-storage uses while giving due consideration to the highest and best uses of the city's land use inventory. Following are the proposed amendments to the city's self-storage standards. So staff proposes 5 new definitions to be added to the Thousand Oaks Municipal Code. 3 definitions are proposed to remedy potential confusion between self-storage, warehousing, and wholesaling uses. Additionally, definitions are proposed for a caretaker unit and a mezzanine. The full definitions for each of those are provided in the staff report and ordinance, but in summary, as we look at a self-storage facility, wholesaling, and warehousing, a self-storage facility is to provide locations for the private storage of goods, but not the sale of those materials. whereas warehousing and wholesaling provide locations for materials and goods which are intended to be involved in the manufacturing, distribution, and/or sales process. Warehousing and wholesaling uses, per our definition, specifically preclude self-storage uses. For this presentation, we're only highlighting the definition of self-storage on the screen, but if the Planning Commission has questions about any of those, we're here to answer questions about those. According to the Self-Storage Association industry publications, the site selection is dependent on a variety of factors, including ease of access, proximity and density of customers, expected growth, current storage saturation levels, availability of land, appropriate zone, and commuter traffic patterns and visibility. Based on staff's research, self-storage facilities are destination locations which do not solely depend on enticing pass-by vehicle trips to patronize these businesses, which is similar to warehouse and wholesaling uses. Self-storage facilities typically have building shapes and sizes which are also similar to warehousing and wholesale uses. These factors make them physically more compatible in industrial zones than commercial or residential zones. Staff's research has also shown that many cities in Southern California have implemented restrictions on the distance self-storage facilities must be from freeways and arterials. The intent of this distance requirement is to provide prime visibility and access locations to the economic generators and/or civic institutions in a community. There is a concern about the large concentration of self-storage facilities within the city, as the use competes for space in buildings that could house a variety of businesses. Self-storage facilities do create short-term economic generation while developments are being constructed. However, self-storage facilities are not long-term economic generators, as they create few permanent jobs. Moreover, self-storage facilities may displace economic generators, such as biotech and life science uses or commercial uses, which typically generate more permanent jobs in comparable square footage. In consideration of the prior slides and the city's guidelines for development within the corridors of 101 and 23 freeways, which were adopted by the city in 1991, staff proposes the following location-based standards that would allow commercial and industrial economic generators to take primacy of the most visible locations, while self-storage facilities would be allowed to develop on less prominent but still accessible sites. First, we propose to eliminate new self-storage uses in the C2 zone and from the entirety of the Thousand Oaks Boulevard specific plan. Second, we direct new self-storage uses to be located within the M1 and M2 zones. And third, we prohibit new self-storage facilities within 1,000 feet of the 101 freeway, as well as the 23 freeways, and 500 feet from the center line of arterials. The slide that's on the screen today shows that the self-storage facilities would be prohibited in what's shown as the red, yellow, and green bands, which are superimposed on the map. And this slide is specifically regarding the distance from the center line of the 101 freeway. This next slide shows that self-storage facilities would be prohibited in the red, orange, yellow, green, and blue bands, which are superimposed on the map. And these collective bands indicate the 500 feet from the center line of the arterials within the M1 and M2 zones. As far as development standards, to maintain the development of compatible structures in the M1 and M2 zones, staff recommends retaining the industrial development standards for the front, side, and rear setbacks, height, and minimum lot size for self-storage facilities that would be located in the M1 and M2 zones. The M1 and M2 zones do not have a maximum lot size for other industrial uses. However, current city regulations limit self-storage facilities to parcels which are no larger than 5 acres. Staff proposes establishing a maximum lot size of 2 acres for self-storage facilities, to steer self-storage facilities into smaller industrial properties with an intention of preserving larger industrial properties for the economic generators. On this slide with the development standards, you'll notice there's an asterisk on the front setback slide, and that's what this next slide talks about. So self-storage facilities do not attract a large number of people to their facilities, and their facilities have historically been inward-facing. Collectively, this means that a typical self-storage facility does not create a hub of activity visible from the street. The self-storage industry has introduced two activating trends, which are actually moving in opposite directions. The first one is that the industry has moved toward fully automating their facilities. While this reduces costs for the self-storage facility, it also decreases the level of activity experienced at the self-storage facilities as no human interaction is needed. On the other hand, self-storage facilities have begun to be built with mixed uses, consisting of office, retail, and restaurant components on the front of their buildings, such as the one seen in this picture. The current city regulations require self-storage facilities to first include an office or retail development as a component of their development on the street frontage. But the current regulations don't require it along the entirety of the building. And two, to locate the self-storage facility itself behind the office and retail use, with the minimum setback of 100 feet from the property line along the street frontage. To make self-storage facility locations more active, especially as experienced from the street, the proposed regulations before you would embellish the current regulations, making the current ground floor street facing requirement follow one of the two setback options as presented on the screen. First, if the building fronts onto a street directly, office, retail, restaurant, and/or caretaker uses would be required along the entire frontage of that building for a minimum depth of 20 feet. Or the self-storage facility could elect not to do that, but then the entire building consisting of the self-storage use itself would need to be placed behind a building on the same parcel. For clarity, we wanted to let you know that a self-storage facility could elect to use the office and retail space that would be on the ground level for their own needs. So it could include not only an office, restaurant, or caretaker use, but their own retail and office uses to help serve the public. Additionally, a self-storage facility shall include one on-site caretaker unit for one or more persons employed by and residing at the self-storage facility, as well as one on-site management office. According to the Self-Storage Association, about 50% of the self-storage facilities nationwide have a residential caretaker apartment. Local operators shared that the industry is actually moving away from caretaker units due to the fully automated facility trend, but caretaker units do exist within our self-storage facilities within the city. Staff recommends a caretaker unit requirement for 3 reasons. First, it's to activate the site. Second, to provide on-site management. And third, to add an additional level of security simply through the presence of an on-site manager. If constructed, the caretaker unit would be counted as a new residential unit that would contribute to the city's regional housing needs assessment allocation. So a review of the literature provided A review of the literature provided a history of the self-storage industry, evolving from metal and/or concrete unconditioned buildings with easy exterior access to the multi-story conditioned buildings with higher architectural and landscaping standards. And the slide that we have before you shows what is considered first, second, and third generation facilities, as well as some images as how they've evolved over the years. Although the self-storage facilities can be designed to achieve a higher level of architectural design, Self-storage facilities, by and large, have not traditionally achieved that distinction. So, the city's existing regulations require design review for new industrial development using subjective design guidelines. And to elevate the architectural characteristics of self-storage facilities while also harnessing the self-storage industry's architectural trends, the self-storage industry, and to insert a level of objectivity to the design review process, staff recommends standards for self-storage buildings. Of those involving the building's form, the architectural standards that we've included focus on designing buildings which have staggered vertical walls, recessed doors and windows, and roofs overhangs designed for solar shading. Storefront glass systems are required for the office, retail, and restaurant spaces, and spandrel glass is proposed to be prohibited. Spandrel glass, just to let everyone know what that is, it's essentially a glass face that you can't see through. Typically, it consists of a piece of glass with a piece of metal behind it that doesn't allow someone to actually see the activity happening within a building. And our regulations, we want to see what's happening inside the building from the outside of the street to promote that activity and that activization. And finally, we're looking for our buildings to be to provide 360-degree architecture. In addition, we're proposing some changes or requirements for the entrances and access. First, self-storage facilities shall not have exterior access to individual storage units except for units which are designed to store motorcycles, automobiles, and recreation vehicles. Units designed for vehicle storage may have exterior access, but the access is to be fully screened from this by the building, fully screened by the building as viewed from the street. Enclosed interior corridor access to self-storage units is required for all the storage units which are not to be used for storing vehicles. And a dedicated covered loading zone is to be located at building entrances connected to that interior corridor. Elevators, lifts, or ramps are required for projects with 2 or more floors. Pedestrian-friendly elements, such as trellises, pergolas, or walkways between rows of evenly planted trees are going to be required in parking areas leading to the main entrance and along the building fronting the public right-of-way. And parking areas shall also be screened from the public right-of-way with decorative walls and landscaping. To ensure that the city's next-generation self-storage facilities in the city meet the highest operational standards in the industry, staff recommends requiring self-storage industry's operational trends as our operational standards. Industry trends not only cover security and lighting systems, but they also recognize self-storage and niche interests that require off-site storage of materials in conditioned space. Additionally, staff suggests adopting standards to allow the continued growth of the transportable pod self-storage use that's been developing in the industry. But those facilities, those pods, are to be located behind the building, screened by the building itself as viewed from the public right-of-way. And in summary fashion, staff recommends operational standards related to the various topics which are on the screen, and those are currently included in the draft ordinance in detail, but we're not going to go over those specific details, but we're available for any questions that you may have about those. A few notes about accessory uses and prohibited uses. So accessory exterior storage within secured transportable pod units shall be confined to the area to the rear of the principal building or the rear 2/3 of the property. In terms of prohibitions, the draft regulations include prohibitions on the habitation within the self-storage units themselves, storage of toxic or hazardous materials, sale or distribution of stored goods, the operation of a business out of any storage unit, and finally, the prohibition of truck rental and the exterior storage of recreational vehicles and boats from or on the property with self-storage facilities. While most of our standards that we are proposing are introducing some regulations, this one is actually is related to parking, which would ultimately result in fewer parking spaces being needed on these properties. So the city's existing regulations do not include explicit parking standards for self-storage facilities or caretaker units. Self-storage facilities, their parking requirements are currently calculated using the warehouses standard. And that criteria requires one parking space for every 1,000 square feet of gross building area for the first 5,000 square feet, and then one additional parking space for each of the additional 5,000 square feet in the building. In addition, one parking space is needed for every 250 square feet of the gross floor area for incidental office use. As self-storage facilities do not generate much activity, an excessive amount of parking spaces are required by the current regulations. Based on a survey of multiple jurisdictions on municipal codes, staff recommends reducing the parking standards. Specifically, self-storage facilities would have a minimum of 5 spaces per facility, consisting of 1 space for every 100 units, or fraction thereof, with a minimum of 3 parking spaces. Additionally, 2 spaces would be required for the manager's office. Required parking shall not be rented as or used for vehicle storage, and a dedicated covered loading zone would be located at building entrances for each 10,000 square feet of gross building area. In addition to those standards, we've also created a standard for caretaker units, which would require 2 parking spaces, either enclosed or covered, per caretaker unit, plus 1 additional space per unit for guest parking. And the caretaker standard, it's not specific to self-storage facilities. Any caretaker unit within the city would be subject to that regulation. So as a result of implementing the location-based changes that staff is proposing, as well as the maximum parcel size that we're recommending, all of the existing self-storage facilities within the city today would become legal non-conforming facilities. Existing self-storage facility operators could continue to operate their lawfully existing facilities consistent with their existing permit, which is in effect as of the date the municipal code amendment and specific plan amendment are adopted. The proposed municipal code language includes language specific, which specifies legal nonconforming self-storage facilities could be modified in the future to increase their sizes, increase the size of the building and expand the use by the lesser of either 8,000 square feet or 10% as the size of their 10% of the size of their existing permitted building, again, which is in effect as the date of the MCA or the specific plan amendment. And let me go ahead and repeat that because I just stumbled through that. The existing regulations that we have on the books today allow legal nonconforming uses to expand, but it limits it to either a growth of 10% of the size of the existing building, not to exceed 8,000 square feet. So our existing facilities, our existing self-storage facilities would be able to take advantage of that same code provision. Any additions to an existing facility, however, shall be required to introduce a caretaker unit into that new square footage. But they could also utilize the proposed parking standards that are being proposed. The square footage of the caretaker unit, again, shall be part of that 10% expansion area. The new addition shall be required to implement all the development and operational standards within the addition, and they may, but not shall, they may apply the same operational and development standards to the rest of their facility, so not the addition, but the existing facility. Should a non-conforming self-storage facility use cease operating for a period of 6 months or longer, it shall be deemed to be abandoned, and their underlying permit would be of no longer standing. in terms of permitting facilities, based on a geospatial analysis of the current parcels implementing the proposed location-based changes and the maximum parcel size standard, approximately 30 parcels could contain a new self-storage facilities. As proposed, no new self-storage use shall be allowed by right. New self-storage facilities would be reviewed by the Planning Commission at a public hearing. A development permit would be required to permit the physical structure, and a special use permit would be required for the self-storage use. No changes are being proposed to the required discretionary development permit or special use permit findings. The decision makers would still be able to place specific conditions of approval on a project as their use is not permitted by right. A modification to an existing legal nonconforming facility would be processed at an administrative level with a minor modification to the original SUP or development permit if all development standards were met. Otherwise, the request would be raised to the Planning Commission for review. So we did look at the general plan as well as the economic development strategic plan as we developed these regulations. And we found that self-storage facilities are a recognized need and use in the community. However, the provision of these facilities must be balanced with the general plan's policies and our economic development goals. Self-storage facilities, again, are not economic generators, but they compete with commercial and industrial properties for development opportunities. The proposed self-storage regulations attempt to elevate the self-storage facilities available to the city's residents to the highest industry standards, while also limiting the availability of land for self-storage facilities to prioritize the continued growth of the city's economic engines. Allowing but restricting self-storage facilities is consistent with the commercial and industrial goals and policies of the Thousand Oaks General Plan. And as we hit the home stretch here, the project has been determined to be exempt from the requirements of the California Environmental Quality Act. Pursuant to CEQA guideline sections 15060C2 and 3 and 15061B3, which state, CEQA applies only to projects which have the potential for causing a significant effect on the environment. Where it can be seen with certainty that there is no possibility that the activity in question may have a significant effect on the environment, the activity is not subject to CEQA. We find that that's an appropriate classification, as a proposed municipal code and specific plan amendment will restrict the construction of new self-storage facilities to the M1 and M2 zones, subject to a future discretionary permit. As future proposed developments would be subject to their own project-specific environmental review, the proposed municipal code amendment and specific plan amendment would not have a significant effect on the environment, as no projects are actually before us today. And therefore, the items before you today are exempt from CEQA. So as our final slide here is a staff recommendation. So in conclusion, the proposed municipal code amendment and specific plan amendment will provide implementation and regulations specific to the self-storage facility industry, considering both the city's general plan and economic development strategic plan, our peer jurisdictions' adopted regulations, and industry trends. Staff recommends that the Planning Commission approve the draft resolution recommending that the City Council find that the Municipal Code Amendment and specific plan are exempt from the provisions of the Environmental Quality Act, pursuant to, again, those CEQA guideline sections 15060, C2 and 3, and 15061B3, and adopt a resolution recommending that the City Council introduce an ordinance amending the Thousand Oaks Boulevard Specific Plan, known as SB 20, and the Thousand Oaks Municipal Code to modify existing standards and establish new development and zoning standards related to self-storage, mini-storage, and similar uses in certain zones, and to recommend the City Council determine the amendments to be exempt from CEQA. Specifically, amendments are proposed to SB 20 Appendix A, the Land Use Table, and the following sections of Municipal Code Title 9, Chapter 4. add sections 9-4.2528, self-storage facilities in Article 25, amend sections 9-4.202, definitions in Article 2, amend section 9-4.2105, permitted uses matrix, non-residential zones, and section 9-4.2106, limitations on specific uses in Article 21, and amend section 9-4.2402, parking spaces required in Article 24. And if the Planning Commission agrees with us, you can simply say, move the staff recommendation rather than repeat all of that. So with that, that concludes my presentation, and Chair Newman, we turn the floor back over to you.
Thank you very much, Mr. Kolowitz. Commissioners, are there questions of staff? I'll start this evening at my left. Commissioner Link.
Thank you, Chair, and thank you, Mr. Kolowitz, for the presentation. I'm curious whether the requirement for the mixed use or the first floor commercial is perhaps saddling any applicant with a use that he may or may not be able to use if the intent is to keep these developments away from any kind of major street. So if we are limiting the amount of frontage or traffic that is able to get anywhere near these places, are we then requiring them to have something that is going to get no traffic whatsoever?
Commissioner Link, so by putting in these facilities that would potentially draw development or customers, we find it a way to activate the space, perhaps from adjacent industrial uses. You know, if we were thinking that maybe a restaurant would go into a facility, would that draw from other industrial uses rather than sending those back out into the community in other locations? A thought that, comparable thought is the Sidecar Cafe that's located in the, generally speaking, the south of the Lawrence area, out in Rancho Canayo. That type of restaurant use at a facility like this might be beneficial to the general neighborhood and provide a little bit more activity on the street, as well as at these facilities. So there's a potential gain, if you will, for the number of people that would be visiting these facilities and maybe even discovering them as time goes on. So it's a balancing act as we're looking at it, but ultimately the goal that we're trying to achieve is to not create dead space in the community. So we do find that that is an appropriate standard both for the city's own economic interest and activeness of these facilities, and something that we also find the industry leaning towards. It's not something that's being implemented in all facilities. I don't want to express that, but it's certainly something that is happening with the industry themselves.
So I guess that begs the question, how many locations do we have? I mean, I can think of at least one other perhaps off of Townsgate. There's a restaurant within that industrial park, but how many other locations do we have where there are retail or restaurant uses within industrial areas that are draws, aside from the two that I can think of right now?
That specific answer I don't know, but this is an opportunity to actually create that as well. But I'll turn over to Planning Manager Kearns.
Thank you, Commissioner Link. The two that you're thinking of are the only two I can really think of too. The Italian restaurant and then the cafe. There are other uses. There's the wine use. I think it's Naboo or on Townsgate as well. But there are other non-industrial uses in these areas.
Side Street Cafe. Do we want to let everybody know what their hours are at this point? I mean,
Sorry, I was trying to think of the two places you were thinking of.
okay.
That's the one we're talking about. So 2 to 3, I would say.
Two to three that I can think of, yeah, or at least just the two. Yeah.
Existing ones.
Existing.
But there
Okay.
could be others. In theory.
There could be, but I mean, I'm thinking at this point, if there aren't others that are using industrial space existing, then the chances of then this being activated in the future are probably slim to none, but that's just one man's opinion. And if it was mentioned earlier, I apologize if I completely missed it. It was, there was quite a bit of information in your presentation, but with the proposed regulations, especially with regard to the setbacks from the center lines of arterials and freeways and major streets, what percentage of properties are now developable with self-storage?
Commissioner Link, great question. We actually didn't drop the actual specific percentage. As we're looking at the total number of M1 and M2 parcels within the city, there's currently 476 M1 and M2 properties in the entirety of the city. Putting that in context, there's approximately 52,000 parcels within the whole of the city. Of those 476 parcels, only 30 would be developable or available for the development of new self-storage facilities. So if we're looking at rough percentages, that leaves about 7% of the M1 and M2 properties available for new self-storage facilities.
Okay. And I kind of wonder just out loud, is the intent of some of these regulations to just make it so fiscally unattractive to develop self-storage that we in essence just sort of nip the proverbial bud and not, I mean, try to make this so difficult that we no longer have self-storage? I mean, I can understand in certain cases having climate control when you have wine storage, but requiring that to be in an entire complex then again makes these facilities very expensive to run. And if we don't hear from the Thousand Oaks Climate Action Coalition or anybody else about refrigerating self-storage units that don't necessarily need it, I'm sure we probably will at a later date, but I just wonder if some of these requirements for operational characteristics maybe are above and beyond where we want to be, even if we are limiting ourselves to 47 parcels.
So I'll start. The intent is to prioritize our properties for our economic generators first and foremost, rather than put on economic burdens, if you will, for the self-storage industry. That said, as we look at the existing 15 developments that we have today that are operating without the higher level echelon that the industry is bringing, we're looking at supplementing those existing facilities with higher end facilities. So there would be a mix of potential units or self-storage facilities within the whole of the city.
Understood. I think that's all I had. Thank you.
Thank you. Commissioner McMahon.
That was a very thorough report. I don't have a lot of questions. Let's see. Do most of our current self-storage facilities have caretakers there already?
Not all of them have them, but there are a few that do. One that comes to mind is the Extra Space Storage over on Grande Vista. They have about 1,000 square foot, 2-bedroom caretaker unit above the entrance in the office. But I'm not sure if anyone else does.
Mm-hmm. And then it's interesting to me that if a current one wants to expand, they have to modify their property so that it meets with the new criteria. I mean, there's a lot of criteria. Would that be all the setbacks and all the designs on the outside exterior walls and the roof articulation and all that? Is all of that going to have to change for them?
The new standards would only apply to the new portion of the building, and staff feels that that is a reasonable and achievable requirement for any of the proposed additions that would occur.
Okay, so they're not going to have to retrofit the original.
That is accurate.
Building,
They
okay.
could if they wanted to, but it's not a requirement to retrofit.
Okay. And then I noticed that we're only applying to parcels that were created prior to July 1st, 2011. I'm wondering the reasoning behind that.
Commissioner McMahon, thank you for that question. That's actually one of the current regulations that's on the books today. With the introduction of the new standards, we actually get rid of that particular standard.
Okay.
And then any parcel that would meet the requirements geospatially and or the minimum maximum parcel would be available.
Okay. And I think that's all my questions. Thank you.
Thank you. Commissioner Lanson. Commissioner Bust.
Thank you, Chair Newman. Yes, thank you very much for that presentation, Mr. Kolowitz. I do have just a couple of questions. I saw the list of the actual physical number of storage facilities. Did we do a square footage per capita calculation by any chance? Because I would assume that that would probably be a greater indicator of the usefulness of storage.
We did, relative to our fellow jurisdictions, if you will. And what was interesting is when we talked to our self-storage operators about the per capita standard, what they pivoted to was that the greatest indication in terms of self-storage was actually the leasing rates and how quickly things filled up rather than per capita itself as a measurement. So in that instance, they talked about the public storage facility that was located on the west end of town, right off the 101, right near Wendy. I forget the specific location, but we could pull that up if needed. The Hollywood storage facility. That particular facility is a 1,300 unit development, and they told us that it had leased up within about a 95% leasing within about a 6-month period. So that's the factor that the industry uses in terms of, is there a demand for these facilities or not, more so than a per capita sort of evaluation.
I don't follow. Are you saying that you consulted with every facility on that list from every city and got a 95% rate, or just one specific place that you contacted?
Thank you for the follow-up. So when we proposed these regulations, we reached out to the existing operators for the 15 facilities within the city of Thousand Oaks, of which the operators that participated in that call, they talked about their experience in the city, and Public Storage in particular was the one who shared their experience of that leasing rate.
So this is anecdotal data?
It's an anecdotal for that particular one.
Okay.
But they also spoke on behalf of the number of facilities that they have across the country, that the leasing rate essentially is the thing that they follow for trying to determine if there's actually demand in a community.
Okay. But I'm still, so the answer to my question is no, we don't know. Because we have the same number of facilities that Camarillo does, but we don't know if they have more square footage of storage over there than we do. Also, Westlake has 2 of these, which is a very adjacent neighbor of ours. So within this general area, there are 17. I'm literally curious how much storage space there is in town, is what I'm asking.
Yeah, to that specific question, no, we didn't get the information
Okay,
from all
so
the
we don't
fellow
know that.
jurisdictions regarding the size of all of their existing facilities.
Okay. The other thing that you mentioned while you were speaking was there's niche uses. You mentioned that pharmaceutical companies use storage for this. So have we consulted local businesses as to whether or not they are availing themselves of this storage space, and whether it would be necessary for a number of our corporate partners to have these places in existence and neighboring them?
We did not reach out to our existing businesses in town, partially because where does that list end, as we start reaching out?
I don't know. You're the one that brought up the niche uses.
So what we did do,
So you know better than me.
so what we did do is we looked at the industry data as to where it's going, and it was interesting because wine and pharmaceuticals kept getting brought up over and over again in the different.
And those are 2 huge things in town.
Correct. And in particular was the pharmaceutical uses, which identified the temperatures and the humidities which were needed for potential pharmaceutical goods. And those are the ones that we included within the draft ordinance itself.
Okay. So, and then you did mention that you did try to get feedback from existing operators. You said specifically Public Storage participated. What percentage participation did you get from the 15?
Of the 15.
Or number.
Yeah, of the 15, we had a total of 5 individuals participate in the meeting, some of which represented multiple facilities.
Oh, okay. Cool. All right, so 5. All right, and so we did get a statistic of 95% occupancy in the one facility. You said that that there's a variable rate and that their determination of saturation is based upon that occupancy. Would we be characterized as saturated, underserved?
I think that's maybe a question that might be best left for existing operators when it comes right down to it. I saw earlier that
Well, we're literally proposing something that will be a limiter, a governor on a free market enterprise. So we should probably know what we're throttling here.
there is a level of need, I would say, in the community that was acknowledged by the operators. Exactly if we're at saturation point or not is a general question that I would say is maybe unknown to staff. We did not do a market study, so I can't answer that with authority.
All right, no problem.
If I may, Chair and Commissioner Buss, certainly when we did the moratorium or the urgency ordinance, we had a couple of applications that were pending that raised concerns to council about whether or not this continuing influx of self-storage facilities were too significant for the city in light of the percentage that we have for available.
I agree, because my follow-up question would be, what was staff recommendation for Willow Lane? Because we actually changed residential property into a storage space up there.
Correct. And so I think at the time it was showing a concern about the number that we were receiving. And ultimately what happened is we brought the urgency ordinance to City Council to consider, and they took the step to put a moratorium on it for this. Again, it's 1 year, or it was 45 days plus the second one, which is 10 months and 15 days for the 1 year. And then they also gave direction to staff to they encouraged staff to come up with a recommendation for ordinance changes within the 1 year. Because as you know, we can actually, or council can actually extend the moratorium an additional year, which would take it to 2024 if they wanted to. With that said, I think Mr. Colwitz also stated that we have continued to receive questions about self-storage and inquiries as to whether there's a land available for self-storage. As you can guess, obviously, with your background, self-storage is a very lucrative type of use. When you think about, for example, his comment about the 1,300 unit at 95% occupancy.
I was actually kind of personally curious how the concentrated wealth of this community can impact that as well. I mean, we're talking about buying cars, storage that we've dealt with in this.
That is true.
We're talking about wine right now. We're talking about pharmaceuticals. We're
Right.
talking about a large number of items that are very, very valuable. And in the process, if because we're talking about this, we're talking about the needs of our community.
Right. I think as he mentioned, the niche kind of situations, I think the only one I'm aware of, and I wouldn't even call it a self-storage facility, frankly, is the one that was brought before you with the unique request for the storage of those vintage cars, and it wasn't, the applicant was actually the representative of the person. I can't remember even the name of the person who owned these cars.
Exactly what I'm talking
On
about.
Townsgate, right, and or it might have been by Lavery Court or something.
So my question, I guess I'll give it to you, is in a situation like that, would that still be possible to do after we pass these ordinances?
Yeah, I think so. And I think one of the things that was unique about that was that there's this component about selling those vehicles like in a one-on-one kind of private kind of sale, not open to the public, but by invitation for these very unique cars, apparently.
Yeah, because there's a very specific thing about here about not being able to sell from
Correct. So
there.
that was a little different category. I think overall, I want to emphasize that.
I'm just curious because I'm literally just trying to understand what
Sure.
we're recommending.
Sure.
And so that was going to be my next question. Was
Right, right.
that one that we passed, would that guy still be allowed to do that if these ordinances exist?
Yeah, I mean, I have to look at that case specifically, but I'm pretty sure that was what made that unique was also the sell component of selling an automobile in that location, because that was part of his request was not only to be able to store the vehicles in a
sell them.
unit, but also these one-on-one kind of situations where people come and look at a vintage car, and then after that say, okay, I'm going to buy that car.
Because I imagine that when we're talking about like wine storage, that's going to be a very similar thing.
Yeah, I
People
mean,
don't hang on to wine bottles just because they want to throw a party. They are an investment.
Right. I don't know if staff has looked for our city. I'm not aware of any personally in our city itself, Thousand Oaks, that we have that kind of unique storage kind of capability.
Okay.
But I think it's also important to note that when city council gave staff direction, it was the effort by staff to look at all these different kinds of cities and jurisdictions that were kind of similar to Thousand Oaks to say, what is the current kind of formula for these facilities? That's why you see these new things such as the caretaker unit. It's not new, but just unique for that we're adding. AC or HVAC was unique, right? So things like that.
All right, I'll move on to my next question. We'll stop belaboring this. I apologize. The last thing I just wanted to ask you was, when we were talking about adding mixed use, frontage access, all that stuff, but we're simultaneously discussing reducing the parking requirements, would a proposal come forward that had additional retail space have an additional parking requirement for that retail, or is that exempt? I thought you were going to ask that one.
Commissioner Boss, good question. We would calculate the parking for that additional office space or retail as we typically would for any other use.
Perfect. Okay, cool. I will cease questioning now. Thank you very much.
Thank you. Commissioner Lanson.
Thank you, Chair Newman. First and foremost, Mr. Kolowitz, thank you very much and welcome to the city. I'm sorry you did not get a standing ovation as our recording secretary did, but you didn't do it all in one breath like she did. So maybe next time. No, I appreciate that was a lot of information, and I very much appreciate when you would look up and see the stares on our faces that you needed to break it down a little bit more and go through it. This is a lot of information to go through. By going later on, my fellow commissioners asked most of the questions, but I want to kind of just ask a few basic ones. There's been no objection received to this application, correct?
That is correct. We have received no, actually, since we sent out the notice, we haven't been contacted by a single proponent or opponent of this set of regulations.
And that would include the two applicants whose applications were pending when the moratorium was issued, correct?
Yeah, that is accurate.
Did anybody at the city talk to those applicants? Did they even communicate at all with the city?
We had spoken to them after the city council moratorium was in place for the additional 10 months and 15 days, and gave them the opportunity to either withdraw their application, keep it alive and see what happens through this process, or get their money back, and they chose that route. They got a refund, full refund of their application filing fees, and the applications were withdrawn.
Okay. So at that point, we've received no further information or communication from them. This issue, from what it indicates in the staff report, is obviously not unique to our city. It's happening throughout cities that you talk to, and I'm assuming even around farther than that. Is there any county or state discussion with regard to implementing any kind of rules that we would want to make sure we're consistent with? If any are being discussed?
Yeah, Commissioner Lawson, no jurisdictions specified to us anything that's, or even the APA for that matter, specified any new standards that are being developed, if you will, for self-storage facilities. I would say that our regulations that are being proposed are very robust and may become something that other jurisdictions regularly look at. There are other jurisdictions in the area that have been following us, so I'll leave that statement very broad, if you will, but we may be setting a new standard.
I did a quick search for potential lawsuits. I didn't see any that were on this issue. Are you aware of any lawsuits or other potential court orders that might impact what we're doing as part of this process?
Commissioner Lawson, thank you for that question too. We, working with our city attorney's office, we looked into that and we did not see anything that's related to that type of question. And on a similar subject matter, something that's been on everyone's mind is the state's been awfully active with land use decisions. Is there anything relative to land use considerations regarding these type of uses? And the short answer is no. The state has been looking at changing various standards related to commercial uses, and indeed just passed a few bills related to commercial and housing, but nothing in prior sessions or anticipated in the future legislative session addresses this issue of industrial lands and any modifications specifically to housing.
So conceptually speaking, there wouldn't be a chance that if we did this process and all of a sudden through some of these laws that there's a housing multi-use that gets approved that's right next door to the public storage facility. That would not be something that would end up happening.
That's not anything that we're anticipating right now. It's not showing up in our crystal ball. That said, the legislature sometimes surprises us, so I don't want to say never, but as
You
we,
mean SB 9, right? That's exactly what you're talking about.
all sorts of different regulations over the years, generally speaking, but nothing is apparent on the horizon.
And then one last area that I'm looking at is you said to the extent that the existing operators cease operations for 6 months, it would be deemed abandoned. Is that they would lose the CUP entirely for that property, or exactly what would happen there?
The short answer is yes. They cease the operation, it's, the use disappears, and then it would be available for whatever would be allowed per the Thousand Oaks Municipal Code, per normal standards.
To the extent that the owner sells the business or property to another owner, though, that still would then be grandfathered in.
Correct. It runs with the land. And as long as one operator to the other doesn't cease operations for a period of 6 months or longer, the operation would be able to continue. So in the instance where someone would sell and they move out, new folks move in, presumably a self-storage facility operator would want to keep the existing tenants. But even if that didn't happen, as soon as they start up the facility again, if that happens in a period of less than 6 months, they would be able to keep on keeping on.
And I'm going to ask one last question, which kind of is related to a project before you got here. Does this set of new concepts create any kind of precedent with regard to potential rules that may apply to other types of uses of a business on an ongoing basis for the future? Or is that a case-by-case situation?
Well, these regulations are specific to self-storage, so it would apply to those businesses outside of self-storage. I don't believe that these would apply. This is really a narrow silo, if you will.
Okay, thank you. Nothing further.
Thank you, Commissioner, and thank you again, Mr. Kolowitz. I thought your presentation was excellent. You stated in answering another commissioner's question that a specific non-goal of this exercise was to put economic burdens on self-storage operators. I wonder if any analysis was done on their customers. Is there the potential here for an unintended consequence of inflation in self-storage costs because we're capping the number of such facilities in town?
No, Chair Newman, no, we did not do that analysis.
Okay. And on a related note, you did, as you stated, you did outreach to operators of existing facilities, and the staff report states that their opinion is that these new rules would pretty much preclude development of new facilities. Did any of them object to that or find it a bad thing?
The existing operators that we spoke to didn't go down that path anymore. So all I could say is they did identify that it might preclude additional development.
All right. And then just for my understanding, there are a number of criteria in these proposed revisions that could be construed as somewhat subjective. And as you know, we've recently had a series of state mandates that forbid us to use subjective standards at all in other areas. But I'm just checking, I presume that's not the case here. So that in areas like compatibility with surroundings, which can be subjective, we're okay doing that in this case.
Yeah, Chair Newman, that is correct. The only objective standards apply to residential development. The city has retained their police powers to be subjective on every other use and provision, if you will, in our municipal code.
Good. I'm glad to hear that, because I think even in residential cases, even with good intentions, we still do things that are inherently subjective in ways, but that's an editorial comment. Moving on. The proposals here include some very helpful definitions of terminology to say, this is what a self-storage facility is, and here are some other kinds of uses that are not self-storage, such as warehousing and wholesaling. And I just want to be sure I understand the ordinance itself or the changes to the law. I did not see anything that would change usage guidelines or permissions for those other uses. This is only changing uses for self-storage. Is that correct?
That is correct.
Okay, very good. And then following up on a line of questioning Commissioner Buss had, we've actually had two cases involving automotive storage. One is a relatively recent one on Townsgate, and then the other is older. It was in 2014. We had a case on Old Conejo Road that involved certainly restoration plus storage and possibly sale, I'm not sure. But it was certainly restoration and storage of exotic automobiles. And I didn't see those included in the list of storage facilities here. So are those covered in the warehousing use, or how would those be categorized?
The short answer is yes, they would be categorized either in the warehousing or wholesaling sections, because those both involve sale of materials. And self-storage is all about the storing private items which are not intended to be sold.
Okay, so out of scope for, if either of those applications, I just want to be sure I understood the answer to Commissioner Buss's question. If either of those applications were to come before us today, we would be able to consider and approve them without these changes coming into play.
Chair Newman, that is correct.
Okay, very good. And then my final question is just I want to be sure I understand the changes in parking standards. If there's a hypothetical 100-unit facility, I think if I understand it, that 5 spaces minimum are required.
Chair Newman, that is also correct. 3 specifically for the units, up to it's 300 units are anticipated to be in these. So 3 spaces for that, plus 2 specifically for the management office.
Right. So my question on that would be, a 5-space requirement would assume 5% customer visit at one time. Are there ever situations, or what would happen in that hypothetical case if customer number 6 comes along? Where would that customer park?
So, Chair Newman, thank you for that question. In the regulations, not only are there the individual parking standards, but we also required a separate loading facility relative to the size of the building. So 1 loading zone for each 10,000 square foot of the building.
Okay.
And that loading zone is directly attached to the interior corridor that would lead to all the self-storage facilities in the building. So there would be a variety of ways of individuals to park on site.
Okay. And then as a follow-up to that, did any of the operators you spoke with consider this 5% requirement to be unreasonable?
None of the operators that we talked to got into that level of detail. Essentially, they saw that their existing facilities get to continue operating as permitted as they are today, and did not dive into the details.
Okay, very good. That's all the questions I have. Commissioners, are there any additional questions of staff? Commissioner Link.
Just had one follow-up question. I am to understand that there is a specific plan number 16, which applies to the Amgen Center. Don't know, I didn't have much time to comb through the several hundred-page document, but I imagine self-storage is not a permitted use within that specific plan. Okay.
No, it is not. It's the only specific plan that allows for self-storage is SP 20, which is the downtown plan.
So then there's probably another chunk of the city that would be removed from the maps that were shown as developable based on the setbacks from the center lines of arterial streets and freeways.
To a degree, the specific plans do equate on their land use maps to the M1 zoning in most SP documents out in that area, SP 15, SP 16, SP 7. They all relate to a correlating land use map. So if it has the M1 designation there, then we can apply it there. But that map that Scott prepared was designated or demonstrating where those uses could be allowed in those areas.
Understood. And then just an editorial for the rest of my planning commission. I just looked it up, and for 200 units, it generates 36 trips per day. So over the span of 24 hours, you'll expect 36 cars, actually 18 cars, 1 to go in and 1 to go out. So the chances of needing more than 5 parking spaces for 200 units is slim to none. So it's reasonable.
Thank you for running the numbers. I appreciate it. Commissioners, any other questions of staff? Very good. We turn now to public comment. We have 2 public speakers this evening, so you will have up to 5 minutes apiece. We have 1 remote speaker and 1 public speaker who's present with us. We'll begin with the remote speaker, just because I got that first. That is Brian Miranda. And for the record, Mr. Miranda, we ask that you state your name and city of residence. Good evening.
Good evening. Can you hear me?
Yes, we can. Please go ahead.
Great. Appreciate it. My name is Brian Miranda, Regional Vice President of Development for Public Storage, the largest owner, operator, developer of storage in the world by a wide margin. I oversee new store development and redevelopment for the Western U.S. and have been here for 8 years doing exactly this job. Commissioners, you had some excellent questions, comments, and I wish I could address them in 4.5 remaining minutes. It's going to be tough to get everything in there. The outreach that has been stated was not really outreach. We had 1 hour-long conference call on September 23rd, and I received the same presentation you did, so I'm trying to address this quickly. A lot of good questions. Storage per capita is actually the appropriate term for the industry. Number of facilities is meaningless, and I did not say anything about rental rate. I'm just trying to clear up some of these questions really fast before I get to the body of this. I also stated that we're at 95% occupancy, and we're at 95% occupancy within 6 months, with 1,200 units, obviously showing the significant demand in the city and the surrounding area. I did object clearly, and I guess I'm going to follow up with written objection as well after this meeting. These new standards will preclude additional storage development. They are extremely limiting. Limiting new facilities and or expansion of facilities, one of the commissioners mentioned, will this increase costs? It absolutely will. Supply, demand. Less supply, more demand, prices go up. Including retail in most locations where storage is located will result in either vacant, retail, or at a minimum will not command rent, therefore making it impractical to build. So I was just trying to address some of those comments really quick, so I'm gonna try to zoom through the rest of this. We purchased the 9.6 acre site known as the Jaffa facility roughly 3 years ago. It's comprised of roughly 150,000 square feet of storage and 43,000 square feet of office/industrial. Our new facility is climate controlled, secured, energy efficient, with access to units from the interior only. Property is mixed use, however, it isn't mixed use the way staff is requiring. We always intended as part of our redevelopment to intensify the use as additional storage demand continue to grow. This ordinance makes any expansion impossible. Commissioners, you had some excellent questions. I hit that already, sorry, I'm typing at the same time. I'm going to state the punchline first. The city doesn't want more potentially productive land to be taken up as storage. I understand the goal and therefore limiting new facility development addresses this goal. These standards make it effectively impossible to develop new storage. The easy answer, however, to address strong demand is to allow existing storage uses to expand to meet the ever-increasing storage demand. And it's clear storage demand is always increasing. Every year we have a higher percentage of the population that uses storage. With regard to the outreach on this new zoning code, again, we were provided this 17 days ago. Provided feedback. There are 2 major issues with the lack of outreach and how it impacts our $50 million investment. First, our use is now going to be legal non-conforming without outreach or discussion. This is a material impact to our property rights. Second, with collaboration, we could have helped improve what you're looking at today. While the research staff performed resulted in many appropriate conclusions, there are various issues that could have been resolved with industry participation. I'd be happy to work with staff going forward. The staff report executive summary highlights the research performed and the resulting conclusions. Supply was analyzed by looking at the number of facilities. As I mentioned before, that's wrong. Storage per capita is the appropriate methodology. Rental rate is not the appropriate methodology. The obvious conclusion with how fast we leased up is that there is tremendous demand, and and shows there's unmet demand. Storage isn't an economic generator while not directly in the form of sales tax or jobs. Storage supports businesses to be more efficient, requiring less, more expensive real estate, such as office retail. Examples, architects, engineers, attorneys, et cetera, have records they keep. Retailers store excess inventory. Residents store their snowboard and their holiday decorations during the off-season. Otherwise, they have to rent an extra bedroom. And with new multi-family development, they don't include storage as residential densifies. Let's see, although the new code proposes we can expand up to 8,000 square feet, it's not practical. The caretaker's unit, that's not industry standard anymore, that's been gone. The requirement of ground floor retail on the entire frontage makes it impractical. We'd have to tear down our existing facility in order to add it. It also requires a minimum of 100-foot setback from the street.
Mr. Miranda, I'm sorry, I need to ask you to wrap up.
I'm very close, if I might. Within 1,000 feet of the 101, we front the 101, and a maximum of 2-acre parcel, we're 9.6 acres. The change in zoning will just freeze us in time. To be clear, we're not going anywhere. PS owns the facility. The first facility was built 50 years ago, and we keep them all, so it'll just stay the same way it is. Really like to engage with the city to incorporate
Thank you, Mr.
some standards
Miranda.
that are a little clearer.
Thank you. But before you go, Commissioners, are there any questions of Mr. Miranda? I have one. You mentioned, sir, that these changes would affect Public Storage's $50 million investment. What does that $50 million refer to? Is that all on Townsgate, or is that spread across?
Yeah, that's all Townsgate.
Okay. Really?
Yeah, we bought the facility for $20.5 million from Jafra.
And then the additional upgrades would be $50 million. It would bring it to
Correct.
$50 million total.
Correct, roughly, with the intent to, have further investment
I see.
in the future.
Okay, thanks for the
But that future investment would be above the 50 million.
Right. But the development cost, including the initial purchase, totals to $50 million.
Correct.
Great. Thank you for
Yes,
that
sir.
clarification. Okay, we move next to Mr. Alexander Vagos. And again, sir, please come to the podium, and we ask that you state your name, because I may have butchered it, and your city of residence. Good evening.
Good evening, everybody. My name is Alex Vagos. I am the property manager and the on-site caretaker of North Ranch Self-Storage here in Thousand Oaks, and I live on-site at the facility. I would like to express the opinion of myself and my company that we found the implementation of these new regulations for self-storage industry have not been taken into account the feasibility of the plans, the contributions of the operators to the relevancy of the plans that they have come up with, and the lack of understanding of their technology and new ways that self-storage currently operates. The presentation of the proposed regulations deemed incomplete, distant from the reality of the current means of operation and functionality, and lacked an in-depth study of California Business Code that governs our industry. These regulations create an unnecessary burden to our future plans of expansion and on any other companies planning to expand in the area. This proposal was created without consulting industry professionals in the region, but rather going from nationwide studies, magazine articles, and general website information. This does not address the specific special needs in each community and each state as well. Feasibility studies were left out from the presentation information as well as professional insight of any kind. Regional analytics are not valid as we live in a state that relies on commuter commercialism. Our particular region is unique in many ways, as I know that other managers will agree that making regulations tougher on the self-storage industry in the area will not benefit anybody cost-wise. The excessive requirements proposed are more aligned to a small mom and pop, creating it hard for newer companies to kind of expand here. Requirements of the on-site caretakers becoming a thing of the past as many facilities across the country are moving towards kiosk systems. Requiring new facilities to incorporate this position along with the required domicile access requirements, such as being the domicile on the frontage of the road, would be difficult for new facilities to incorporate, or if we were to expand to make sure that we are complying with all that. The primary point we're trying to make being related to these regulations is based that it needs to be reevaluated, that we need to go into this with some local industry input. Thank you for listening, and please reconsider enacting these regulations at this time.
Thank you, Mr. Vegas. Commissioners, are there any questions of the speaker? Thank you, sir.
Thank you.
We go now back to staff for any rebuttal comments.
Chair, if I may, I'm going to start off.
Mr. Heer.
Out of turn here, probably. I apologize, Mr. Kolwitz, but you heard a couple speakers. First of all, I want to make it clear to the public, and I know all of you know this, but it's not uncommon that as a city evolves, they're going to change ordinances, especially in the zoning code, to reflect new needs, new plans, and new public safety features, and that's exactly what we're doing here. So this comment about you created a legal nonconforming, yes, that is true, but as Mr. Kolwitz stated, clearly stated, these uses are allowed to continue, and they can expand to a certain extent without triggering any type of modification requirement from the city as far as before this board or this commission. So the comment that you've created a legal nonconforming, that is true, but it's not uncommon that as cities grow and evolve, that's going to occur at times. You see it sometimes with a sign code, you see it with, obviously this is a perfect example, but that does happen. We also, I want to stress that when we brought this in front of City Council, they made an action to adopt the urgency ordinance or the moratorium. Then they made a second action to adopt that second part of that moratorium for another 10 and a half months approximately. And so when they do that, they gave instruction to staff to do the outreach, to do the investigation, to do the research. And frankly, the comments that it's been 10 and a half months and they don't know about this is shocking when we had that whole hearing and it wasn't something that just went underneath the table. It was something that was out in the open, and we had a public hearing, 2 public hearings, and a lot of controversy behind it. So we actually had that. It was on. Everyone knew this was happening and that we were working towards this. The other fact is very important to note is that we are allowing self-storage facilities in our city. We are doing it now. As Mr. Kolwitz said, the way it's worded right now, the way it's rated, there's about 30 parcels that can be developed. That is true. But that doesn't mean that it's not impossible, that these conditions that we're putting in are something that we looked at in the standards. And I'll give you 2 examples that were made from the 2 comments that we received tonight. One of them was the person said, hey, I live at the location. I'm a caretaker at the location. And so when we look at that as a caretaker issue, that is a condition that we're putting in there. But as an example of, we have one that just spoke up today at this meeting to say, yes, I'm a caretaker at a location. So the idea that that's not appropriate to me just doesn't make sense when the fact is that we actually have those examples in our own city. So it's not, I mean, it's something for you to consider. I'm not saying you don't have to allow that, but what I'm saying is that it's not unusual. These standards that staff brought before you are not unusual, that we brought them out of thin air, or we bring them to you out of thin air or something like that. The other one was HVAC, right? That's obviously an expense. And staff, I'm going to tell you right now, the staff looked at that as a interesting condition, because we said, wow, that's expensive, right? But the first speaker, what did he say? The first thing he said was, hey, we have added AC or HVAC to our system. Why? Because he thought it made sense for his business. And sure enough, we think that would make sense for the businesses. If you have self-storage, you know the heat that we have in Southern California. Certainly that makes sense to have that as a condition. It's not unreasonable to add that as a condition. And again, it's before you. If you think that is too much of a condition, you can certainly voice that. But the reason why we brought that before you was because Mr. Kolwitz and his team did all this research and made the investigation, did reach out to various locations, including various cities in our Ventura County and surrounding areas. So it's not like we didn't do the research and did the effort. And so I guess I'm a little challenged by the fact that this is new to anybody because of all the outreach that we have done on this case. So those are two very important parts. Again, legal nonconforming is not uncommon when you have a change in your zoning code. And the fact is that our code does, these new changes do allow these self-storage facilities to come into play. Yes, have we put it into a little bit more control, more architecture? Yes. More of an impact use as far as the frontage? Yes. Did we take it away from our 101 corridor? The results of that is yes, that is true. We have done that. But that's with reason. That's not with making it up. It's with looking at our needs, looking at what we want, looking at what this council directed us to do, and then looking at the parcels that we can do. M1 zone and M2 zone is a perfect area for these things. We're taking it out of SB 20, which again, in staff's position makes complete sense to do that. And we're taking it out of commercial, which again, is not an unusual thing for us to do that or to make that recommendation again. Again, these are recommendations for you to consider. Those two specific subjects are within your control to say, hey, we think this is a good, or we don't think this is a good idea. We can have that discussion. But as far as a surprise or as far as a, I can't believe this is happening kind of comment, I think that's frankly not from the facts that we've had and the time that we put into this thing. It's been, again, a year of time that we've been, or not a year, but certainly 8 months of pushing this forward to make sure that we can meet, again, council's request to have this brought before them before that first year moratorium ends. And that's what staff is trying to do. And Mr. Kolwitz, I apologize for that, taking your time there, but if you have any more comments, please feel free to bring those forward.
Staff actually does not have any additional comments to provide. Patrick, you did a great job for us, so thank you for that. But we're available if the Planning Commission has any questions
Thank you,
for us.
Mr. Heer, and thank you, Mr. Kolwitz. Are there other questions, Commissioner McMahon?
So our first speaker represented public storage, and they're currently rehabbing the Jafra site. It's in the process right now, is that correct? Are they?
No, that facility is currently operational.
It is currently
open, yeah.
operational.
Correct.
Which is the site that is in the process right now?
The one that's under process
On
right now is
Willow
off of
Lane.
Willow
Okay.
Lane.
So will they have to adhere to the old rules or the new rules?
They're fully entitled, so they are complying with what was entitled when they got approved last year. Or
Yeah, last year.
Last year, yeah.
Okay, thank you.
Other questions of staff? Kudos for Mr. Heer. Okay, very good. All right, I think then we will go ahead and close the public hearing, and I will now open up the floor for discussion and/or a motion. Commissioner Link, the floor is yours.
Where to begin? At the beginning. I can fully support the restriction and elimination of having not public storage, but storage facilities, mini warehouse, however you want to call it, within the Thousand Oaks Boulevard specific plan, because I don't think that meets the definition of the spirit of what was envisioned for the Thousand Oaks Boulevard. It's not the highest and best use. We are trying to encourage commercial development, short of the retail/restaurant frontage that would be included, that would be 20 feet deep. That's honestly about all I can support. I think what has been packed into this is frankly just a little too onerous. I think Commissioner Buss made the comment that we are in essence, I think it was Commissioner Buss, that we are in essence compelling a specific type of development by developing these regulations and assuming that the kind of development that we are hoping to see is going to meet these, what I believe to be very onerous definitions. And do we really want to make that requirement? Are we really going to eliminate capitalism, in essence? I mean, are we going to sort of pigeonhole the next development into what it is that we want to see? And how far do we take this? I mean, first it's storage facilities. Well, where do we go next? Obviously, we can't do it with residential, but Do we then take our industrial facilities and then push them in the direction that we want to see? Well, maybe now we want to do industrial condominiums and we want all industrial space to be for sale units as opposed to rental or what have you. I can't see myself putting these kinds of restrictions on future developments. Granted, we didn't hear a large swath of the industry. I mean, we do have, 15 facilities in the city, and we heard from 2 of them. That's generally a lot better than what we hear from in most cases where we have representative developments in the city where we hear very few comments. Most of the time it's residential, but we're not having 120,000 people come to planning commissions and giving public comment despite the fact that there are 120,000 people living here. So frankly, that we heard from 2 out of 15, I think is a larger percentage than we generally hear from with respect to these kinds of hearings. And I do take that to heart. I think that, and rather than pick this thing apart, I mean, I could start taking off the things that I don't think should be in here or should be optional, the operational requirements for one, the setbacks with respect to the freeway. I'm not sure where we were heading with regard to not having certain facilities in view of the freeway. There's various buildings along the 101 that frankly I don't want to look at, this building included, but here it is. Yeah, I'm sorry, Thousand Oaks City Hall is not an attractive building. It's just, that's just me. I think we've just put too much on this. So with the exception of eliminating self-storage from specific Plan 20, I can't support this. So my motion would be a no recommendation to City Council.
Based on the findings. So you're making a motion to reject or to recommend non-passage.
Correct. So our motion, or the motion that is
of the
being asked of us
amendments
is to make a
stated by
recommendation to City Council to adopt these
All right.
changes.
So you're making a motion.
I'm making a motion
And
of,
just in process terms, I need to be sure we get the motion stated properly.
I mean, unless we can start picking at this
No,
one by
you're,
one.
You're fine doing that. I just need to.
Okay, so I'm going to make a motion that we make a recommendation of, or a no recommendation to City Council for adopting these changes.
Of a recommendation to reject the changes to the parts of the statute as stated by staff. Is that?
So I think that it would have to be a recommendation in which that the city council does not adopt the resolution and ordinance as presented by staff. So
Correct.
Your motion is specifically to say no to the recommendation that staff presumes, presented to you. And that would include finding it exempt and also including the amendments to the Thousand Oaks Boulevard specific plan, Thousand Oaks Municipal Code, and as further outlined by staff.
Exemption.
Exactly. So with that, I think I did hear from Mr. Link, some of his reasoning behind it. So that is what you have before you as far as the motion.
So thank you, Commissioner Link. We have a motion to reject. Is there discussion? Commissioner Buss.
I was actually afraid to speak first because I thought somebody would give the motion and then I'd speak against it. But since Mr. Link started, I am kind of in the same boat as Mr. Link. I do understand the motivation for limiting the number of storage spaces that are built because obviously we don't want to become a warehouse community. But the things that I was thinking about is we are advocating for the building of a significant number of high-density properties. Some of the properties that we've been looking at are as small as, a few hundred square feet for people. I don't think these are places where people are going to live their entire lives, but I've had a garage for 30 years, and it is a godsend for me because at various times in my life, I've needed to store things there. Right now, my garage contains the entire contents of my stepson's life because he's been living with me for the last 2.5 years. And so I do not know the market rates for storage facilities just because of the privilege that I have a house, a single-family home. But we are going to be building a significant amount of housing here that won't contain those things. The state is talking about eliminating parking requirements in general. cars may go by the wayside over the next 35 to 40 years. People won't have garages, and we don't build basements here. So I am thinking in those terms that it could be quite possible that storage spaces become infinitely more valuable as time goes on, for the reasons that some people have described. I also know that I'm involved on the boards of 2 nonprofit groups that have storage spaces. And they're very specifically because of the equipment involved for putting on our fundraising events, for all of the materials we need, all of those things. And I find myself asking questions about how important these are for the activities that happen in a community of any given size, which is why I did ask about the square footage, because it does occur to me that there's probably some threshold amount that is good, and I'm sure industry professionals can probably tell us all day long what that threshold amount is. And I don't know if I want to make a bunch of rules restricting that, not knowing that information. And so my concern is not that I'm opposed to somehow restricting all of this, but I don't want to start firing shots in the dark when I don't know where I'm even standing and which way I should be shooting. And so I agree with Mr. Link, and we'll be following him.
Thank you, Commissioner Busk. Commissioner Lanson.
So I am not a fan of telling people what to do with their property. I believe in the rights of people to actually do with their property what they want to do, subject to, obviously, reasonable restrictions. If we look at the city, again, I'm as old as the city, 1964, we were, again, a goods economy. And then we developed into a service economy where public storage became a very popular concept and popped up all over the place. Difficulty we now face is that we're out of space, and we're facing state guidelines requiring more and more limitations of what we do. So anytime, in my opinion, we can find a way to do things under a local control concept where we can dictate certain guidelines, I like that better. That's why I liked a lot of the zoning things we did before in terms of trying to find ways to accommodate what we're looking for and obviously keep in mind what the state's looking for. In this situation, Commissioner Link and Commissioner Busk have pointed out very valid points, and I don't want to undermine those. My 2 cents, though, is Mr. Miranda and Mr. Vagos. We're talking about potential speculative expansions that were not before us. There is nothing before us as to what they may do in the future as to expanding. So I'm not, in my opinion, prepared to discuss potentials of expansions that haven't been submitted. And there's no other people that submitted potential plans. There's nobody else that objected that looks to build a new facility that's upset, including the one that was subject of limitation by virtue of the moratorium. They're not here. They're the ones that would be the most upset, I would think, by virtue of what we're doing here tonight. So that's not before me. So I'm looking more at, are we limiting things in a way that's reasonably necessary to pursue what our agenda and goals are? And we doing in a way that actually provides what we're trying to accomplish? And yes, there's a lot of rules here. And again, I think Mr. Kolwitz indicated we would be not aggressive. What was the robust, I think is what you indicated with some of the rules. And that is true. The difficulty, though, is we don't have space anymore. We are out of space. We're out of space for a lot of different things, including housing. And if we don't find a way to do things in a way that limits, yes, some kind of businesses. We do that all the time with marijuana dispensaries. We do it all the time with various other types of businesses that we limit where they can go, how they can go, and how they are able to operate. Yes, it creates undue burden sometimes. I appreciate that. At the same point, I don't want to end up not having a rule that then allows this to be built on Thousand Oaks Boulevard, that the state then comes down and says, sorry, you can't do that. And all of a sudden, all of these rules that we have to try to preserve our city go down the wayside, and we're subject to the state's one-size-fits-all rule. So I understand the concern. At the same point, I'm balancing those issues in terms of ultimately what is the best interest, in my opinion, for our city. And it is to have some, again, reasonable process by which to put the public storage facilities in a way that actually gives the best chance of them fitting in with the community. Again, even the speakers indicated, there's a huge demand. I get that. By the way, there's a huge demand of people to live here. 30% more people, I think, want to actually live here than can. That doesn't mean, well, all of a sudden we start building 10-story buildings along Thousand Oaks Boulevard. Same thing. I'm not looking to make sure that every single person looking for public storage actually is able to get a space. No, it's not 10 stories. It's only 6. So in that sense, yes, there's limitations here. But again, I'm not going to base my decision on speculative And by the way, by the way, thank you to both of your companies, speakers, for investing in our city. I would say, though, you got the benefit because of the project you actually built. I mean, if it is $50 million, as Chair Newman inquired, that was based on the existing facility they built. So that's the benefit they're getting from that. To say I'm losing money on a future expansion, that really isn't fair because that's not before us, and it's not something that we should have to consider as part of our evaluation process. So I think at the end of the day, we're looking at terms of lots of different businesses and homes and residential and everything we're looking at zoning. I think this is a reasonable accommodation to put them in areas that actually make the most sense. I don't want them all of a sudden on Thousand Oaks Boulevard next to residential, which again, I'm fearful is what would happen if we did nothing. So I'm going to vote against the motion, I think is the way it would go.
Thank you, Commissioner. Commissioner McMahon.
Well, I'm hearing everybody's arguments for and against, and my first impulse is we have this moratorium that's about to expire. And I agreed with the moratorium. I think we need to keep our business corridor, those properties at the highest and best use, and public storage does not belong there. I agree with the city for that. I'm concerned that if we don't act now,
Excuse me, I think you mean self-storage.
Self-storage, what did I say?
You referenced a specific
Oh,
company.
no, I meant self-storage, thank you.
Self-storage,
Yes.
Public storage we like. They're a good resident,
Yes,
a good citizen.
absolutely,
of
they're
our-
great,
Thank
absolutely,
you.
no. I'm talking about self-storage in general. We don't want them on our business corridor. And I don't know if we can extend the moratorium while we go through the adjustment of our municipal ordinances that we're working on now, or not. I don't know, maybe that's a question for Mr. Heher, if we can extend the moratorium again. I don't know. But I do feel, I agree with you also, that it is a little bit onerous, but you have to weigh that with if we want to have public storage on our business district or not, so I'm really torn. Can I get an answer? Can we extend the moratorium and then revisit some of these restrictions?
So, I mean, my difficulty right now is that you have a motion pending on the table, and so that's why usually I wouldn't speak. I think the answer is that council can make a decision to extend a moratorium if they want to. I will just say that staff was directed to bring something in front of council before the first moratorium or the one-year moratorium expired, and that was the direction that staff received. So that's what we are trying to do. But certainly council has an ability, if they make the findings, that they can extend a moratorium. But I just want to be clear that we don't have any of that direction, nor is that in front of council at any time that we have set.
Okay, I think so. Thank you. So I'm really torn. I'd like to hear our chair's comments before I make any kind of a decision right now.
Okay, I just want to underscore something Mr. Heher just said, noting that the option of extending the moratorium is not a power this commission has to grant, and it's not the question before us. What is before us right now is Commissioner Link's motion to reject the set of recommendations in total. Yes or no? We should reject them or not. That's the question we're debating.
That you are exactly correct.
Right. I want to begin by pushing back a bit on the idea that it's somehow novel or unusual to compel a specific use. I don't think anyone here would be too terribly happy if they woke up tomorrow and found there was a construction company building a hog slaughtering plant or a nuclear waste processing plant next door to their house. And the reason that those uses don't occur is because we have a thing called zoning and property rights. And zoning is literally why we're here and what the planning department and what this commission is established to do. It's not the case that zoning will, quote, eliminate capitalism. Adam Smith, who is widely acknowledged as the father of laissez-faire capitalism, never once advocated for a free market. He advocated for a fair market. And he wrote advocating for the use of some government control. He was not a heavy-handed government type, to be sure, but he wanted markets to be fair, and he recognized that there was a proper role in regulation. So this is not a novel thing. That's the point I'm making. It's not unusual that a government, particularly at the local level, would compel a specific kind of use in a specific area. And indeed, I would argue that that is what has helped capitalism to thrive rather than to be a brake on it. So I don't think what we're doing is in any way unusual or out of step or a rapid departure in any way from what this city has done all along in being a very well-planned community. That's our tradition, and this request that we have before us is squarely within that tradition. With regard to the motion before us, I too see merits on both sides. I'm concerned about the inflationary potential of limiting the number of self-storage facilities we have. We all have too much stuff. We all want to put stuff places. We all are going to have less space if what we think is about to happen with housing may happen. And that is probably a very nice problem for our existing self-storage business owners to have, but it does restrict options for the consumer. And that is an unintended consequence I think we should be concerned about. I also am mindful of, as a business owner myself, of putting too much of an undue burden on any business. I wouldn't be happy about that were I in either of our speakers' shoes tonight. At the same time, in my opinion, I don't think the changes that have been proposed are unreasonable. As Mr. Heer has stated, they do allow existing businesses to operate and within limits to modify their businesses, to expand their businesses without additional permitting or without additional review by this commission. And then if they really want to expand, they can, but there are a set of new regulations that, in my judgment, would be reasonable. And as we've heard from other places, have been achieved in some other municipalities. The other point I want to push back against too is there's been some suggestion that these standards somehow can't be met and have a business still be economically feasible. We've heard that line before. We've had pushback from developers of residential and multifamily and multi-use projects for years saying, we can't possibly do the much greener all-electric construction. It's just not feasible. We can't do it. And then lo and behold, earlier this year, we approved 2 large projects that will be very lucrative for their developers, and they are all electric, so they found a way to make it work. So I don't necessarily think that the rules being put in place here will be an economic break. They may actually incent new and more lucrative uses, and for that reason, I think I will join Commissioner Lanson and possibly Commissioner McMahon, possibly not, I don't know, in voting to reject the rejection. Is that? To vote no on the motion, let me put it that way. Commissioner McMahon.
Okay. So in weighing everybody's comments, and I do appreciate everybody's comments, they were very insightful. My thought process now is I do want to stop the construction of public storage along the business corridor.
Self-storage.
Self-storage. Did I do that again? Gosh, I'm so sorry. I'm so sorry. Self-storage along the business corridor. I think that's really important to the way I see the business district in the future. And with the reassurance that the businesses that are doing business now can continue along the way, and not knowing what the future holds for them, they can still do business along the way. They may or may not choose to expand. That would be their decision in the future. And that there are 30 more parcels that we can have storage on. So I think I will also vote to reject the motion. So.
Thank you. Is there any further discussion? Will the secretary?
Oh,
I'm sorry,
yes.
Commissioner Link, I'm sorry.
I just figured while we're on the subject of fair capitalism,
Yes.
2 points. One, just on my cursory analysis of attachment 3 as compared to attachment 6 and 7, there is one existing self-storage facility that could expand without basically hitting the moratorium, or not or that would have the ability to expand that isn't within the 500 or 1,000 foot setback. So one. So I don't know if that completely precludes their ability to expand at all, or they're limited to the 8,000 square feet. And we already closed the public testimony, so I probably can't ask staff any questions. But we did. But yeah, so just
There's a motion on the floor.
There is a motion
If you
on the
want to
floor.
withdraw the motion, we can reopen the public hearing and go back to questioning.
no,
the
that's
staff.
okay. I just would want
Just
to
in
say
terms
that
of process, that's where we are
it-
at this moment.
As long as we're on the subject, I think that you taking 430 parcels and whittling it down to 37 isn't necessarily fair. So I don't want to misconstrue or say that, yes, we've been down this road and we limit what we do with zoning, but it's a false equivalency to say that I'm going to put a abattoir next to my house and be very mad about it. So I don't want to get into hyperbole with this, but again, let's call a spade a spade. But again, so it sounds like 3-2. I don't know if we need to take a vote for that, but that's...
Yes, yes, there's a motion and we need to vote on that motion. Yes. Will the secretary please prepare us for a vote?
Commissioner Buss?
So I'm voting aye on the no.
Objection.
No. Oh, you didn't call me yet. She wants to know
Sorry, is that a
what you
no?
voted.
So my vote is aye for Mr. Link's.
Yes, okay. All right. Commissioner Lanson?
No.
Commissioner Link?
Yes.
Commissioner McMahon?
No.
Commissioner, Chair Newman?
No.
Motion fails 3-2. Commissioners Lanson, McMahon, and Newman voting no.
Thank you. I don't think we're done here. If we choose to, we can stop right here, or we can continue discussion. I don't think we are done, but if there is interest among the commissioners, we can either continue discussion and/or have another motion. Commissioner Buss.
I think we're at the point where reasonable people are capable of disagreeing about this, and I think we're all pretty comfortable with our positions. I know that Link, it seems to me Commissioner Link is very comfortable at this point, and I still have the reservations I have, and I think a split vote going up to City Council actually will encourage them to kind of delve deeper into the questions we had and carry with them the assurances that other people did. So I think it's actually probably a good message to send to City Council. So I'm comfortable with you guys making a motion and us having a vote.
Commissioner Lanson, I think you may have a motion.
I agree with Commissioner Buss. I think we've done, I think, a very good job of going over all the issues. In fact, I think Mr. Miranda was impressed with all the questions we asked, and I hope City Council does review this and go through our issue. I will go ahead and move to approve the staff report as indicated.
Very good. I want to concur with both of your points and note to Commissioner Link that I too agree that any regulations that we put in impose burdens of some kind and for any business. And I'm not unsympathetic to that at all. I agree that these would be burdens for someone as but that's what we're here for. So I concur that it would send a message to council to go ahead and have a vote the other way. But that would help register your objection.
Sure, absolutely. Fine with me.
Commissioner McMahon? Okay. So Commissioner Lanson, did you make a motion or do you? Okay, very good. So there is a motion on the floor. Do we need any further discussion?
Nope, I just want to make sure we're clear. The motion is to approve staff's recommendation with the minor change to the CEQA, just to make sure that it's not the government code, it says CEQA guidelines for those sections that are listed there.
Right.
That is my motion.
Very good. Okay, will the secretary please prepare us for a vote?
Commissioner Buss?
Nay.
Commissioner Lanson?
Aye.
Commissioner Link?
Nay.
Commissioner McMahon?
Aye.
Chair Newman?
Aye.
Motion carries 3-2, Commissioner Buss and Link dissenting.
Okay, I'll note that there is no appeal period on a recommendation by the Planning Commission to the council. I do want to thank our public speakers for appearing tonight. I appreciate that you're doing business here, and I appreciate your comments, and again, have sympathy with Commissioner Link's comments, that we want this to be a good business environment for you. So thank you for that. And I also want to thank staff, and again, welcome Mr. Kolwitz. Good job. I'm glad you're here. Thank you. Very good. Moving on, I see we have no department reports.
None tonight.
So we will move then to commissioner comments and AB 1234 reports. Commissioners? Commissioner Lanson.
Thank you, Chairman. Just a quick message to the public who may be looking. The voting guide that you got in the mail is rather thick. The mail-in ballot you're going to get in the next few days is probably going to be very thick as well. Please, please take the time to go through it, research it. Don't just basically go off, yes, no, yes, no. Please look at the issues. There's a lot of propositions. There's a lot of judges. There's a lot of people up there who put a lot of time and effort into running. So please do your investment in terms of this process and realize that it's a privilege to be able to vote. But again, make sure you do that work.
Any other commissioner comments? Very good. Okay, we'll move to staff update. Mr. Dugan, are there any follow-up items or announcements?
Yes, Mr. Chairman, thank you. Coming up on October 11th, the City Council meeting tomorrow night, in fact, there'll be a public hearing on the SB 9 involving efforts to increase housing supply. On October 25th, they'll also have a public hearing on this self-storage item. A public hearing will be held on a building code update and the departmental report on Many Mansions Bella Vista refinancing and the fire code update. They're all on the consent calendar for the 25th. For the Planning Commission upcoming, on October 24th, the Planning Commission will have a public hearing regarding a new single-family detached dwelling at 2546 Oak Shore Drive. And on October 31st, there'll be 4 Dish Wireless Communication Facility public hearings.
Very good, thank you. Any other comments? All right then, we stand adjourned until October 24th, 2022. Good evening, Thousand Oaks.